Good afternoon, everyone. Sorry, I thought I was on mute there for a minute. Welcome to the Resident and Family Support Council. For those of you who are regular attendees, you might realize I'm not Lee Moriarty, but she's at a conference today, and so she asked me to fill in for her. My name is Jessica Belsley, and I am the Ombudsman Specialist here for the Illinois State Long-Term Care Ombudsman Program. I'd like to extend a warm welcome to those of you who are attending live and those of you who may be watching this later on YouTube. Today we have Lawrence Wagner with us. He is one of the regional ombudsmen in the suburban Cook County area, and he's going to talk to us about the importance of making healthcare choices, advanced directives. Lawrence, I'm going to just go ahead and pitch it over to you to get us started, okay?
Okay. Thank you, Jessica. As Jessica said, my name is Lawrence Wagner. I am the Regional Long-Term Care Ombudsman for suburban Cook County, except Evanston. I've been in this role for a little over 6 years right now, and in a sense, I think I'm at the risk of setting myself up. I'm a bit uniquely qualified to talk about this issue among ombudsmen because I'm also a lawyer by training, and we do a lot of powers of attorneys for our residents and other people that contact our agency for help. So hopefully today we can cover why it's important to have a power of attorney document and why it is important to choose wisely who you will assign to be your agent under a power of attorney. And just so you know, we usually save questions for the end, but if anyone has any questions as we go along, please feel free to interrupt me and ask your question. I much prefer that over waiting till the end because, when I have to talk uninterrupted for a long time, I think I get kind of monotone and drone on, and no one likes that. So please feel free to chime in if you have any questions. So a power of attorney is just another form of an advance directive. And we have, under the umbrella term of advance directives, we have power of attorney for property, power of attorney for healthcare. We also have living wills, mental health treatment, preference declaration. And while it's not necessarily considered under advance directive, Lee wanted me to touch a little bit on the whole idea of a guardianship, which is in a sense is a totally different beast, but at the same time, it ends up in the same place where someone else is making decisions for you after a court of competent jurisdiction hopefully has determined that you're no longer capable of making decisions for yourself. So all of these different types of advance directives will determine who will make decisions for you when you become unable to do so. And they'll also spell out the circumstances under which that person, the agent, takes over for you in making decisions, and when they don't. Those are all things that are within your control when you create one of these documents. And that's why it's important that you create, well, the documents have to be created before you need them, because if you get to the point where you need them, you're likely deemed no longer competent to make that decision for yourself anyway. So you won't be able to create the document when it's needed, which is important, because if you don't have this advance directive and designate who can make decisions for you before you need it, then it becomes kind of the wild, wild west. In Illinois, we have the Surrogate Act, where the law will set out in order of some importance of who can make healthcare decisions for you if you're not able to and you don't have an agent. But that can raise a whole plethora of other issues in and of itself. So it's vitally important for us, all of us, myself included. I have one. I have advance directives written. Hopefully I will never need them, but should in case I need it, it's there. And it's important for all of us to designate beforehand who we want to make decisions for us in the case that we're not able to. So just a few important terms before we go any further. I wanted to talk about what I mean when I say healthcare. And healthcare really is any care, any kind of treatment or service to maintain, diagnose, or treat any kind of physical and mental health or personal care that we might have. So, I don't want to insult anyone by defining this term, because I think in general, we all have an idea in our minds about what healthcare is. And you're correct, but it's often important to kind of put a formal definition around it. So any kind of care that relates to your health, I guess is probably the shortest way of putting it, but I'm a lawyer, so I like to use a lot of words. So any kind of care that's related to your health is what we refer to by healthcare. One of the other terms you will see in a healthcare document or power of attorney document is the word principal. And the principal is the person who is signing the power of attorney document to give someone else the power to make decisions on their behalf. And the person to whom they're given power to make decisions on their behalf is considered the agent. So the agent is the person who gets the power to act on behalf of the principal. And that's the person that we refer to as the power of attorney. You'll see the shorthand of POA. Another term you might see, which is not really in vogue much anymore, is attorney in fact. That's more of an older term, but it's also a term that some people still use. And then when we refer to a power of attorney, technically we're referring to the document itself, not to the person who acts as power of attorney. Again, we refer to that person as the agent. And then lastly, I want to define the word capacity, which basically is your ability, anyone's ability to make their own decisions. And it's usually when, hopefully, if your document is carefully crafted, it's when you lose that capacity that your agent takes over to make decisions on your behalf. So in Illinois, we have an act, a law that sets forth everything we need for the power of attorney. For those of you who are so inclined, it's 755 ILCS 45/3, and it sets out the parameters for a property power of attorney and for a healthcare power of attorney, and they cover different areas. Obviously, the property power of attorney covers assets that you might own, whereas the healthcare power of attorney just refers to someone who can make decisions about your health. So the property power of attorney, they can be two different people, or they can be the same. So you can have one agent to deal with your property if you happen to have a child or a person you know who is really savvy when it comes to property things, when it comes to money things, when it comes to your house, or if you have a house or any other asset that you might own, then you might want to make that person your power of attorney over your property. And then you might have a separate person who is a more caring person and who might do better in handling your health issues. You can make that person power of attorney over your healthcare, or they can be the same person. You can have the same person to be your agent over your property and as well as the agent over your healthcare. But there are two separate documents. Just to make that distinction, you need to execute two separate documents, whether you're appointing two different agents or whether you're appointing the same agent over both.
Lauren, what if I have two kids and I just want them to share it? Is that an option?
It is an option. Yes, it's not. Let me jump in a little bit. So the POA Act in Illinois has what we refer to as statutory form that's recommended that you use. If you use the Illinois statutory form, you only get to designate one person for each. So one person to be the agent for property, one person to be the agent for healthcare. But you don't have to use the statutory form. You can create if you hire a lawyer, you can do it yourself. You can create your own form, or I've seen forms from other states where they allow you to designate more than one person as your agent. We don't recommend that in Illinois because when the time comes for those agents to take over, if they don't agree, then you have a problem. And I've seen it where it was, I think it was two children it was siblings. In the case I'm referring to, they were the principal designated two of her siblings to be her agents at the same time. And when she lost the capacity to make her own decisions, and those two siblings were feuding, and they could never agree on anything. So decisions really never got made like they were supposed to. So while it is possible to name two different people as your agent for property, or two different people as agent for your healthcare, it is just not advisable. Because if those people cannot be on the same page when the time comes to make decisions for you, then it will be problematic. And the only way the best solution, unfortunately, in that circumstance is for someone, whether it's one of those two people or someone else, to petition for guardianship. And then the guardianship will take precedence over the power of attorney document.
Thanks for that.
So,
There is a question in the chat, and I'll read it, and I'll let you decide if you want to defer till later on in your presentation, because I'm not sure what what the order is. So I'll go ahead and read it for you, just so you don't.
okay.
So, the person said, in order for a healthcare power of attorney to be active, meaning the agent will now make decisions, the individual must be incapacitated in some way or deemed incompetent by a judge, correct? They go on to say, my father is in a long-term care setting and is still able to speak and converse. He has memory issues, but there's no legal paperwork deeming him incompetent. His agent, the stepson, is making all of the healthcare decisions, and my father's too scared to say anything to the contrary. The home is allowing this. How can I assist my father in having his voice and autonomy? It seems there's a lot of coercion, fear, and manipulation going on. In a nutshell, the question is, can you explain how an agent becomes an active power of attorney?
Well, there are two main ways. So when a principal completes the document, they can either make the document effective immediately upon signing, or they can include what we call triggering language. And generally, the triggering language is the more prevalent of the two, where the document will say that my agent takes over making decisions for me when my physician determines that I no longer have the capacity to make decisions for myself. And from our standpoint, that's the type that we would like to see. We would like to see that kind of triggering language, because as advocates for, especially people in long-term care settings, we would like to see people continue to make decisions for themselves as long as they're capable of doing so. But there's one concern though, and that I have, and again, something that I see over and over and over again. Even when the resident of a long-term care facility is capable of making decisions for themselves, whether it hasn't been deemed by a doctor or a court or otherwise, but they're still capable, facilities have a tendency, when they see that POA document, to automatically defer to the agent instead of consulting with the resident themselves, even though the resident has full capacity to make their own decisions. So that's kind of something to look out for, and kind of a downside to having these documents, especially when you live in a long-term care setting, because facilities will automatically defer to the agent even when the principal is capable of making their own decisions. In terms of your current situation, where your father is, I mean, if he still has capacity, he should speak up, and he should assert himself in that situation. And I understand why he may not want to do that. Sometimes they don't want to ruffle feathers with the facility. He doesn't want to ruffle his son's, ruffle feathers with his son. He wants to keep the peace, and I get all that. But if the agent is making decisions that he would not make for himself in a given situation, he needs to speak up, and he needs to assert himself. And if this tension continues to exist, he can go ahead and rescind the power of attorney. He has that power. Now, when it comes to the healthcare power of attorney, it can be rescinded whether the agent has capacity or not. The problem is, if he doesn't have capacity, he will not be able to appoint a new power of attorney. So it's a way to get rid of a power of attorney who's not acting the way they should act. But then if the agent lacks capacity, they cannot appoint a new one, and he or she will be in a situation where they don't have an agent to act on their behalf. And then again, the default though there becomes the healthcare surrogate in terms of making healthcare decisions.
Thanks for that. I think, as you were talking, something that came to mind as far as the current situation from an ombudsman perspective, one of the things that could be beneficial for you to consider is, would a care plan be helpful? Would it be helpful to get all the players around the table, the father, the agent, yourself, or other family members, to talk through the care issues and to prompt, as an ombudsman, if I was in the room, I would be prompting the resident, is this what you'd like? How do you feel about this? What do you want in this decision or in this situation? So I think there are maybe some approaches that you could explore with the ombudsman to talk through as well. It's a difficult, it's a really difficult situation,
It is.
especially if your father feels like he doesn't want to speak up. He doesn't want to ruffle feathers. He doesn't want to do anything to make the stepson upset. Then you're a little bit stuck. But I think to remind him, you, if he still has capacity, this is your life, right? You chose him to make the decisions you want, you would make if you couldn't. And those are the decisions he should be making. But as Lawrence mentioned, we sometimes see that that's not how it plays out, unfortunately.
Right. And since we started down this road, we'll stick with the power of attorney for healthcare. As when you give an agent the power, you're pretty much giving them the power over your life completely. They can decide what kind of treatment you receive, when to begin those treatments, when to end those treatments. They can decide.
How am I running low on memory?
Yeah, they can decide where you
How
live.
can I not?
If you can be admitted to
Now
a
I can't
nursing
hear
home
this.
or otherwise. So one of the things that when we are counseling folks on giving someone that kind of power, we say make sure this is someone who knows you well, if at all possible. Make sure the person knows you well. Make sure the person knows what your values are, because they make decisions of they make end of life type decisions. They can make organ donation type decisions. It goes whether you want to extend your life, whether it's more important for you to have a quality of life versus a long life, or vice versa. What kind of final rights, if any, you will have as you get to as you're facing end of life in your journey. So it's critical that the person you choose is someone who knows you well and someone that you can trust, who will respect your values and respect your wishes, and by all means communicate those wishes to that person beyond just the four corners of that document, because the document is limited. I mean, there's room on the document to write in all kinds of things that you want. But I think it's also important that this is someone that you know well enough that you're having conversations with. Like for me, I tell my kids, I said, look, I said, when I die, the one thing I do not want you to do is spend my money on a big funeral. Don't do it. I said, I would not want my money spent that way. And that was something that came out of a personal experience of my own. And I'm not trying to get too far down the personal track here, but when my own mom died and we were talking to the funeral home, these guys want to sell you like the Cadillac of coffins. I mean, they want us to spend like $15,000 on a coffin. And I'm like, no, this is something we're going to put her in and put her in the ground, and that's it. We'll never see it again. Why do we want to spend that kind of money on it? So, every aspect of your death and burial, there's someone who wants to charge you for something exorbitant. And so, I tell my kids all the time, from just coming out of that experience, I said, when it comes to that point in my life and you have to make those decisions, I don't care what you do. You can go to Home Depot and buy some strips of pine wood, build a box, and put me in a hole. I'm fine with that. Of course, that's not legal, but it was just a point of illustration that you don't have to go out and spend all this money. So, it's those kinds of things that you want to make sure that the person that you will designate understands about you, what it is that you value, and how will those values show up and be interpreted once that individual is in a position to make decisions for you.
Lawrence, I got a question for you, and I'm putting you on the spot, and I don't know if you have an answer to this. So I'll just give that disclaimer ahead of time. Are you aware of any guidance or a document or something that could help people think through those questions? If you've never experienced the types of questions you may be facing at end of life, you may have no idea the types of conversations you should be having with your loved ones? And I can't think of a resource off the top of my head, and I didn't know if you're
There is. I'm aware of it. I can't think of the name of it off the top of my head either. But
Sorry to interrupt, but this is Karen. I'm the person putting stuff in the chat as you guys talk. There's a really good resource on end of life. A lot of times palliative care and hospice organizations have them, but the one I'm familiar with is by Compassion and Choices. However, Compassion and Choices advocates for individuals being able to terminate their lives on their own terms. And I know some people are opposed to that.
Thanks, Karen. You know what? Actually, another attendee put in the chat 5 wishes, which I forgot
That's
about
it.
that, but that's a great
Yes.
resource. I think you can probably just, if you just Google 5 wishes, I think that you could probably easily find it. But yes, I forgot about that resource, but that's an excellent resource to just
Yeah.
help you think about. And these conversations can be difficult, right? And so to have something kind of guiding those conversations. Lawrence, one other question. You were talking about a little bit about what happens after. Oh, and somebody put a link to 5 wishes in the chat. Thanks for that. About, your wishes after you die. Does the power of attorney keep going? Like what makes a power of attorney document end?
Generally speaking, it ends upon the principal's death. However, the principal can indicate in the document itself if it wants to continue beyond that for this reason, so that the person can make those kinds of decisions for them after they die. But typically, if the principal does not designate as a date or a circumstance under which it ends, it will end when the principal dies.
Thanks. Oh, one more question. You mentioned about the doctor, the triggering language, and it could be that the doctor determines capacity. Is it always the doctor? Can the nursing home decide that, well, we think today that person can't make their own decision, so we're gonna just decide? Is that possible?
It happens. It's not supposed to.
Okay.
No, it should be a treating physician. And I'm sorry, and I laugh because, as an ombudsman, we see it all the time where the facility does try to do that. And this is another area in which it's important when for folks to reach out to their ombudsman to step in and make sure that's not happening. I mean, it needs to be your treating physician. And when it's not, and for obvious reasons, right? Is that there are times where there may be times during the day when someone may not be quite with it, pardon that expression, but that doesn't mean they don't have the capacity to make their own decisions. But nursing homes would tend to be quick to latch on to that and say, well, when we spoke with him, yesterday afternoon, he was only oriented by 2 or maybe by 1, and we don't think that we think that means he can't make decisions for himself anymore. But that's just a snapshot in that person's entire life and experience. That is not a health diagnosis by someone who really has the training and the expertise in determining whether an individual lacks the capacity to make their own decision. So again, it's something that we see nursing homes try to impose their will for whatever reason, and we have to remind them that that is not their role, and it needs to be a physician who makes that decision.
There's a comment in the chat where somebody says, we hear a lot, quote, well, their BIM score is
Yes.
fill in the blank, and
Yes.
that's what we're basing our decision on. So are you saying that that's not appropriate?
Absolutely. Absolutely. And because the BIM score is just a snapshot, right? And a person could be having an off day for whatever reason that would impact their BIM score. And then why we want a physician to do it, because a physician, hopefully, if this is someone who's been treating them for a while, the physician will have a more full picture of who this person is developmentally, with their capacity, physical, mental, and otherwise. So the physician is in the best place to determine whether this person has capacity. or whether that low BIM score was just an anomaly that happened because, you know, they were having a bad day or for some other reason. So
Thank you.
yeah, facilities like to point to BIM score, but we shouldn't let them. So again, so choosing an agent, we dealt a lot with that. Under the law, though, your agent has to be at least 18 years old. The agent themselves has to have capacity to make decisions. And for the healthcare agent, it cannot be the principal's primary healthcare provider. It has to be someone independent of that. And, you know, getting back to the whole idea of whether you can have more than one agent, I already said that you can't, or you shouldn't anyway. However, you can designate a successor agent. So you can write the document to say that you know, child number one is my agent, but if child number one is no longer able or willing to act as my agent, then child number two will be my agent. And on and on and on, depending on how many children you have and how many of them you want to trust with these kinds of decisions. And then, of course, you know, once the documents are complete, whether it's for property or for healthcare, they should be signed by the principal, and they should be witnessed. We always recommend at least 2 witnesses to sign off to say that they witnessed the agent signing this document. When it's the power of attorney for property, the document not only has to be witnessed, but it also has to be notarized. We tend to put a stronger emphasis and tighter restrictions around designating an agent for your property than the agent for your healthcare. And we do the same thing when it comes to revoking a property power of attorney. Excuse me. Unlike healthcare power of attorney, where you can revoke even if you lack capacity, you cannot revoke a property power of attorney if you, oh, I take that back. You can revoke it. You can't designate a new one. Nope, I'm confusing myself. You can't revoke a power of attorney for property. Sorry if I'm confusing people. You cannot revoke a property power of attorney unless you have capacity. Whereas with the healthcare power of attorney, you can revoke whether or not you have capacity. Hopefully that straightens it out. So all of the things that we talked about for the healthcare agent also applies for when you're designating someone to be in charge of your property, because you have to remember at this point, this person is going to handle all of your financial life. You know, if you own real estate, they're the ones who will be able to buy or sell your real estate or buy more real estate in your name if you have that kind of resources. They'll be the ones who would pay your bills, who will deal with your bank. If you have investment instruments, they're the ones who will deal with those as well. They'll deal with, you know, any kind of benefit that you're receiving, Social Security, pension. You know, when it comes time to do a Medicaid application, if you get to that point in your life, they would be the ones responsible for navigating that. I mean, they basically will handle any kind of financial aspect of your life. As a general matter, again, just as with healthcare, you can choose to limit the power in any which way you see fit, or you can expand it beyond the things that the document says. So if you see the document, and I probably should have had one on the screen to share with you to see what it looks like, but the document enumerates different areas in which your property agent can act on your behalf. You can expand that as you wish, or you can restrict that as you wish. But however you do it, you need to make sure that, you know, again, it's someone you trust, someone you know that will carry out your wishes and will do it the way you would have done it had you not lost capacity to do so. So in terms of it taking effect, it's similar to the healthcare power of attorney. It can take effect immediately if that's the way it's written, or when there's a triggering language, any kind of triggering language, but the most common type is that when your treating physician determines that you lack the capacity to make these decisions for yourself.
Lawrence, there's a question about power of attorney for property, and the person said, is it correct that if I have named a successor trustee in my living trust, that I don't need a power of attorney for property? Made a note, I have moved my assets to this trust.
Well, if all your assets are in trust, then yes, you don't need a property power of attorney because the trust document lays out how to dispose of, if you will, your property. And you know who your beneficiaries are, who your trustee is, and how that property is supposed to be handled. So if all of your assets, all of your property happen to be in a trust, you don't need a property power of attorney.
Could there be a situation if the trust would run out of money and an application for Medicaid or something would be needed eventually? Or is that not, does it not play out to that point?
Well, I mean, if the trust runs out of money, it will likely dissolve. Because there will be no assets for the trust to manage.
I'm just thinking then, could there be a potential to need a power of attorney for, I guess there would, I don't know. You
Well,
don't
I
have to
mean,
be
you
an
can-
agent
you
to
can-
apply for Medicaid, so I guess that's not necessarily a direct step.
Right, and you can write those documents to account for any kind of specific circumstance you can anticipate. The more circumstances you anticipate, the more complicated the document can become. But it certainly is possible to write, any scenario in it that you can think of that might become the reality of your life at some point.
Thanks.
Of course, then you can end up with a pretty large, cumbersome document that no one wants to read, but
It'll cost a lot more, right? The more
it will
complex
cost
you
a lot
make
more,
it,
yeah,
the more money the
it-
attorney preparing it is gonna make.
right. You'll buy your attorney a new boat or something. So, I want to come back to this point because it's very important, and it's choosing the right person to be your agent. I can't emphasize it enough because I've seen too many times where an agent will act in a way that the principal would not have acted in those circumstances. And we know this because the principal says it. And we know this because sometimes they even act contrary to what is laid out in the document. And that becomes problematic because the only way to enforce that is for someone to take them to court. And I don't think there are too many people out there who are vested enough to want to spend the time and the money to take a power of attorney to court because they're not acting in what they consider to be the principal's interest, or at least the principal's intended interest when they designated them to be the agent. So,
Would you briefly talk about the durable nature of the statutory short forms and the fiduciary responsibility of agents? I think those are things that a lot of people don't understand based on the questions I get in my job.
well, I'll start with the fiduciary responsibilities first. So the law requires agents to act, really to step into the principal's shoes, which is why I was talking earlier about making sure you designate someone who knows you well and who knows what your wishes are. So they are to make decisions in a way that the principal themselves would have made it had they been capable of doing so. And I think that's as umbrella a statement as I can make about their fiduciary responsibility. If they get off of that and if they start making decisions the way they want to versus how the principal would have wanted them to, then they're no longer carrying out their fiduciary responsibility to that principal under the power of attorney document.
What does the word fiduciary mean? Or what do you mean when you use that term?
You would ask me that question, wouldn't you, Jessica?
You know what? The reason I ask it is because I think for a lot of people not doing legal stuff, we hear it and we think banking, right?
Yeah.
And so, but that's not how you're meaning right now. So that's why I'm like,
Right. It's one of those terms that we use because we inherently, is that the right word? We kind of inherently understand what it means, but when you ask us to define it, it's like, But basically, a fiduciary is someone who has a legal responsibility to act in a certain way.
That's perfect. You should write it down and then
I
we'll
should
know
write it
next
down?
time.
I will.
Right. No, that's a great explanation. Thank you.
Okay.
The other piece of the question was about the durable nature of if you use the short form, which I think she was just getting at the fact that it like lasts until you die or you revoke it.
Right, and that's again, it will typically end when the principal dies. However, you can write in the document itself if you want it to end. Either you can have it end before that, or you can have it end after that. It all depends on what the principal's desire is. You know, if the principal has a will, for instance, and the will govern, you know, what happens to their property after they die, then in that scenario, then the principal typically will have the power of attorney end upon their death, because they know they have a subsequent document which will take over and will designate what happens to their property. Same thing if they have their property in a trust. Right? And if it's in a trust, they know that the trust agreement is the document that will govern what happens to the property after they die. If they don't have a type of document like that, then they may want the power of attorney document to extend beyond their death, so that they can have someone designated to handle the distribution or disbursement of whatever property they may have left. Or and typically that would mean going through probate. We're kind of getting off on a tangent here, but you know, if you have enough in Illinois, I believe it is more than $100,000 in assets when you die, you have to go through probate, and that means typically getting a lawyer, opening a probate case in court. And you're basically making an announcement to everyone you might owe money to that, hey, this person is dead. These are their assets. If you want a piece of it, come get it. If you have less than 100,000, you can do a short form called a small estate affidavit, and you don't have to go through the court process for that. You just fill it out, or whomever you designate, your POA or someone else can fill it out. And I'm not sure where I think you register that with the Secretary of State, but don't quote me on that. And then you can that person can then go ahead and dispose of your assets as they see fit. There's no real mechanism for your creditors to come after you at that point.
Okay, you asked, or you mentioned earlier, the importance of knowing who the person you're choosing to know what you'd want, right?
Yes.
And to that you trust that they're going to act on your behalf. Let's say that you chose someone and they're kind of taking over, even though you still have capacity. Can you change your mind once you've done this?
Yes, you can change your mind. You can, if you see that that person is overstepping the authority you gave them, and you can't rein them in, you can revoke that power of attorney. And hopefully you have someone else you can designate in their stead. You know, because the agent doesn't have to act, but when the agent acts, they must act in the way that you would have acted as a principal in that situation.
So if an individual would revoke it, who needs to know? Like, how does it become, I want to say, official?
You know that's the tricky part. You certainly want to make sure that every institution that you have a relationship with knows. You know, if you have a checking account somewhere, if you're on Social Security, you have to make sure Social Security Administration knows. If you have other investments somewhere, whether it be a retirement account, if you're doing investments for your children or your grandchildren, you have to make sure those people know. You certainly want to, if you're in a facility, you certainly want to make sure the facility knows. And above all, make sure the agent knows. Let that person know that, hey, I am removing you as my agent because I don't like the way you're handling my affairs. And then in the case of a property POA, the person hopefully still has capacity to go ahead and designate someone else that they feel will act more in their interest or the way they would. You know, I think the worst thing you can do is to not have someone designated who can act on your behalf when you cannot, because then it kind of becomes the wild, wild west, especially if you have assets that are worth fighting over.
Okay. Someone asked the question, when you mentioned whether it has to go to probate or not, and that $100,000 threshold, does that include property or is that just cash?
That's everything. That's your entire worth, whether it's
Total
physical
assets.
property
Okay.
or cash.
So when do you think the best time is for someone to create a power of attorney document? Is there a certain point in life? Is there something that should trigger that?
No, I think as long as it's as long as you believe me and accept that it's something that you need, you should do it now. I think the sooner the better. And it's a document that you have it, because you never know. I can step out here, when we're done and get hit by a bus. We all hope for longevity in our lives, and we like to think that we'll live until we're 100, and we won't lose the mental capacity and mental acuity, to take care of our affairs, but we never know what will happen. So
Most of the time, we don't think about it, but we learned some really hard lessons during the pandemic when people got stuck. They were isolated. They had young adults away from home for the first time and they got sick. And because of the various privacy and confidentiality law, parents who usually are footing the bill for people in college weren't able to be involved very easily. So every adult should put these in place. The catch is, and I'm sure Lawrence has seen these in his career as well, once you create it, you've got to keep it up to date. Because I've seen bad things happen by people who created it, didn't keep it up to date, and now they're not in contact, or they don't trust that person, or they're not on good terms with the named agent.
absolutely, and I know it's a difficult thing for some people, because it in their minds it's forcing them to think about their morbidity, and most of us don't like doing that. But we have to change that way of thinking, and just acknowledge that, at some point we will all, maybe I shouldn't speak so absolutely, but at some point we will all get to a stage in life where this might become necessary.
Yeah.
And just based on the work that I've had come up in the last couple months, part of preparing your advanced directives is also being organized with your information, whether it is financial information or whether it is medical information, contacts that you rely on. Because I just recently helped a family who lived long distance. The caretaker husband passed away. His wife was living with dementia. The daughter didn't realize the situation had kind of devolved into a hoarding situation, and this person doesn't know anything about her parents' finances. And you need to have access to some key identifiers in order to access information. And it is a hard road.
Yes, and I don't know, getting back to my personal habits, and I don't know how safe this is, but I have a Google Doc that I created and share with my adult children, and it has all my banking information in it. It has my insurance policies information in it. It has who to contact at my job in it in case something happens to me. It has everything that I can think of that they would have to deal with, if I should become incapacitated or die. And it's a Google Doc, and so they can pull it up, and all the information will be right there for them to see. And it's a document it's a live document. I update it, and every time I update it, they get notified that I updated it, so they can go look at the updates that I made. So something I think that's fairly simple to do. Something as simple as that, it keeps them updated. And I have 4 children, by the way. Not that that matters. But also, you know, for those that and I live alone. So another thing too that I do, and I got this idea from someone else, is that my POA documents are on my refrigerator door. So, you know, if something happens to me while I'm at home alone and the EMTs have to come in, if they look at, I don't know if they look at my refrigerator door, but if they do, they'll see, well, no, this guy has, you know, our return information. And here's who his emergency contact is, so we can call this person to step in and deal with things from this point forward. So just little things like that can help us to ensure that when we do get to that point in life, that the right people know and the right people know at the right time, and those decisions can be made for us.
Yeah, to the question, I kind of knew the answer when I asked you the question about who needs to have one, but we're taking our youngest to college in 2 days. She turned 18, and I actually have it on our to-do list before Thursday, before we leave for college, is to complete your power of attorney document to make sure that's done. But I mentioned that because there actually is a question in the chat that says, I have a 24-year-old son. Does he need to name me as his healthcare power of attorney if something would happen to him, or does a parent automatically get to make healthcare decisions for an adult child that has no spouse?
The easiest way to do it, yes, is for him to name you, because if he doesn't have a power of attorney and he doesn't have a spouse, then institutions will revert to the surrogate law. And again, under the surrogacy law, then, you know, for a single adult, and I believe the first person on that list is parent. So you'll be covered that way. But again, you take the guesswork out of it by designating someone in advance. So it doesn't, it takes the guesswork out of it, and it makes everyone, there's a term I'm looking for, but it gives finality to the decision, and there's no question in anyone's mind who the responsible party is here that should be making decisions on your behalf.
And there are, I mean, you can download the power of attorney short form on the website online
Yes.
and do it for free. Personally, in our household, we've used Mama Bear Legal, which we have to get, you can find a discount code. But it makes it really simple. It walks you through it. And for us, it was just the peace of mind that we weren't missing something major, because, it's like using TurboTax to do your taxes. You can do your
Right.
taxes on your own, or you can pay a little bit of money and have that help, or you could go to an attorney and have them help you. There are also, other than Mama Bear Legal, there are plenty of other legit online services. It should not cost you a lot of money to do a simple power of attorney for healthcare, though. So if someone's
Absolutely.
trying to charge you hundreds, I wouldn't pay more than $100 personally. I don't know what the magic number is, but if someone is charging you hundreds of dollars and you're not going to see an attorney directly yourself, you should find another option, because they're taking advantage of you.
And I'm sorry, and even with attorneys, some attorneys don't like it when I say this, but there's nothing all that magical about what we do. It's just reading comprehension, and especially with this particular document, it's pretty simple to follow. I mean, there's nothing mystical about it. If you have reasonable intelligence, and I'm not trying to insult anyone, but
What are you saying? That I didn't want to do?
I put the resources in at the beginning of the chat. They're posted on most of the human service agencies. Many medical practices, in terms of like hospitals, have them available as a service. And then a really good resource for Illinois is Illinois Legal Aid Online.
Yes.
But I would say the more complicated your personal life is in terms of family dynamics, the more affluent that you may be, it is a good idea to consider consulting an attorney and doing your advanced directives as part of overall estate planning. And you do this for peace of mind. It prevents so many fights down the road. It sets up expectations. I have been a caregiver in my life. I've been an agent under a power of attorney. And this is the story I tell people that it's true. I had a wonderful boyfriend. He had chronic health problems that were diagnosed very shortly after we started dating. He had outlived his parents. He was an only child. He wasn't in touch with any other extended relatives who didn't live in the Midwest. And when he was diagnosed, I agreed to be the agent under his power of attorney literally within about 24 hours after he was admitted and went on chemotherapy for leukemia. His system was overwhelmed with sepsis and he started coding.
Wow.
And he survived, but there's that situation where you're actually asked, what do you want to do? So you have to be prepared to make those decisions. Hopefully it will never come to this. It's like insurance. It's peace of mind.
Right. Absolutely. Anyway,
Yeah, and it can be awkward conversations, but it's either an awkward conversation now or it's an awkward conversation later. Like if it's needed, there are often difficult conversations, right? And so to be willing to have those to make it easier later is often a wise choice.
right. And again, from speaking from my personal experience, when you don't have this document, and that means there are, okay, I'm trying to say generally, but I can't. I'll just say it specifically. So I have 11 siblings. And when my mom was in the hospital and she was facing, her end time, she did not have any kind of advance directive. And under the Healthcare Surrogacy Act, they just group siblings as a group. And, they don't say firstborn, secondborn, thirdborn, fourthborn in order of preference. It just says siblings or children. So we have all these kids in the hospital with different opinions about what should happen to my mom at this point. And it became a problem. I'm not going to say we almost came to blows, but it became a problem. And so when you have an advance directive, at a minimum, you designate who you want to be the person to make that decision. And then, and that person has an out, if you will, because it's not them, it's you as the principal who's saying, I'm making this decision to put this person in charge. And then this person can feel free to have the authority to make decisions. Hopefully it'll be a collaborative thing, but in the event that they can't come to a consensus, then they get the final say as to what happened to you as a principal. So it just avoids a lot of headache, as Karen was saying. But with that, there are two more things I need. Lee wanted me to touch on quickly, and we're running out of time here. So one of them is the Mental Health Treatment Preference Declaration Act, which is 755 ILCS 43. Is similar to a POA, except it deals specifically with mental health. And I know in our world these days, we're emphasizing mental health a lot more than we used to. And so this is one, we don't see it often. As a matter of fact, I've never seen it actually in practice, but it's an option that's out there to, as a principal, to designate who you want to make decisions for you when it comes to your mental health. Now, by all means, you can include that in a regular power of attorney for healthcare. There's nothing stopping you from doing that, but this is a specific tool for designating who's to make decisions for you in the case that you're having a mental health crisis. Again, it's the same kinds of things apply. They can determine what kind of treatment you get or don't get, whether you need to be admitted to a facility or not. And again, as a principal, you can provide any kind of specific guidance that you feel would be necessary should the person need to step in as your agent. And finally, Lee wanted me to touch a little bit about guardianships. So it basically takes the power of attorney concept to a higher level, because with a guardianship, you have the courts involved. So anyone can petition, to be a guardian over another individual. Oftentimes we even see facilities petition to be guardian. The facilities can't be the guardian, but they can do the petition to have someone else be the guardian. And as ombudsman, we don't particularly like guardianships because usually when there's a guardianship, a court has decided that they basically strip away your personhood. Again, unless it's the guardianship is carefully written and carves out certain exceptions, which courts are not very good at. So you don't want to leave it in the hands of a judge to say, okay, I will appoint a guardian over you except for, because they will never do it right if they even do it at all. But at least with the guardianship, there's obviously a legal process, and the petition is filed. The court will appoint a guardian ad litem to do some investigation to make sure that you as the I guess in this case it's a ward, not the principal, that you as the ward actually do need to have a guardian appointed, and then to see who that person should be. Oftentimes when a petition is filed, the would-be guardian is named in those documents. If they're not, again, the law provides generally who the court would look to first, and it usually starts with close family members to see if a close family member would be able to step up to do it. One thing you can do in a power of attorney document is, and this is in the statutory form, you can designate who you'd want your guardian to be should a guardian needs to be appointed for whatever reason. If that happens, then it kind of takes the guesswork out of who will be your guardian should it gets to that stage. But once the court decides that you require a guardian, then a guardian is in place. And again, there can be a guardian over the person, a guardian over your property, or both. It all depends on what type of petition was filed and what type of report the court gets back as to the type of assistance you would need as a ward if a guardianship is put in place. So that's all I will say about guardianship. So Lee won't get mad at me. I touched on it. And that would bring me to the end of my prepared comments. So if there are any more questions, I will take those at this point.
Let me check the chat to see. I don't see any hands raised. I think we caught the questions.
Great job, Lawrence. I always really appreciate you stepping up after I suggest that we have you come back and revisit.
Well, thank you for continuing to volunteer me, Karen. Keeps me on my toes.
Karen, there is one question. I think you put something in the chat about the Illinois Guardianship Association holding a training on October 30th. And someone mentioned the registration.
Yes, I'm just giving the link to where to go, but the registration link isn't yet open, but it will be on October 30th this year. And I can't remember whether I sent an invite to you, Lawrence, with some other information about changes that went on, because for attorneys, it gets free MCLE. It'll be in Springfield, but we will be doing another one probably in the spring in the Chicago area.
Okay. I don't recall seeing that email, so if you wouldn't mind resending it, I'd appreciate it. And it's actually that means that there's one last comment I should make about guardianships that I didn't make. So if there is not an individual to fill the role of guardian, the court can appoint either the state guardian or the public guardian. And the difference is that whether you have assets over 25,000, I believe is a threshold, and if you have assets over 25,000, and this one I always get confused on. I think it then becomes the public guardian. And if you don't have the assets, it becomes the state guardian. Correct. Oh, I got it right. So I forgot to mention that when talking about guardianships.
Somebody asked if the guardianship training will be hybrid or not, and Karen said there's still work to figure that out. So stay tuned for more info there. Lawrence, thank you. We're at the top of the hour. I appreciate you taking time to share your knowledge with us. It was a lot of information, but I think it was really helpful for those of us that know it and maybe are familiar with it. But there were, some nuggets that we learned, and for those who this is new to, kind of just to serve as a foundation to get a good understanding. So thank you for your time. We really appreciate it.
And always reach out to your ombudsman if you have questions or need assistance otherwise. Have to put that plug in there, Jessica. So.
Yeah, no, that's fantastic. All right. Well, I will go ahead and end our meeting for today. The next Resident Family Support Council will be in 2 weeks, and hopefully Lee will be back here, leading the group. So
2 weeks?
take
Wait a
care.
minute. Nope. Maybe
Not
she
2 weeks?
in 2 weeks, Lee will be with us doing a monitoring visit. Maybe. No,
Mm,
that's Wednesday, Thursday, not Tuesday, Wednesday. Sorry. I thought it was Tuesday, Wednesday, but it's Wednesday, Thursday.
yeah. Okay.
Never mind.
I'll be with you too. I don't know if you knew that,
Oh, you
but
could, I did not know that.
yes, lucky you.
Okay,
So yeah,
I'll-
hopefully August 26th. So again, the invite should be out there. The link works for all of these, and we look forward to having you join us again. Take care.
Okay, bye. Thanks all.